Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumile Mateza. The problem of sexual harassment is increasingly coming out of the closet. Companies are starting to realize that the problem is real. Some managers are admitting that it could affect their staff, and more victims are starting to gather the courage to complain. And in terms of recent labor legislation, victims do have legal recourse. Yet most people do not fully understand the problem, its cause, its consequences, or its extent. Even more difficult is the question, how does one deal with such behavior? Before considering the causes and consequences of and possible cures for this deep-rooted problem, we shall have to define it. We shall also describe different types of harassers and consider who are usually the victims. Every man and woman who becomes aware of the implications of this issue can help both companies and individuals to address this insidious and destructive problem. This is Right and Recourse. To discuss today's topic are Ms. Lisa Vetten, Research Associate from Wits Institute for Social and Economic Research, Mr. Chabulani Mabaso, Group Executive Human Capital Services at the SABC, and at our Nelspray studio, Ms. Patricia Lidwaba, Legal Officer from Gender Commission. And at our Durban studio, we'll be joined by Mr. Bukani Mgoma, CEO of Mabala Consulting. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse. Before, however, we get into the bones and marrow of this discussion, let us have a look at this dramatization of sexual harassment.
You could have that ready for discussion at the next meeting.
I have a manager in my division. You all know him. His name is Mark. He's a yappy and he's married. And Cindy works for him. Cindy was very happy in our company. She and Mark worked together as a team. From what I know, Mark is very kind and a real gentleman.
Don't tell me it's one of those stories again.
I don't know what you're referring to, Kevin.
Jane, if a story begins like this, it's either an office party story where both got drunk and they slept together, or she tried to get a promotion by sleeping with the boss, did not get promoted, and is screaming, sexual harassment now. Come on, guys. Don't we know all about this? Oh, and when she starts crying when we ask her questions about the harassment, then we know. Lie, lie, lie. And she thinks we really care.
Let me remind you guys, with the new code of good practice on sexual harassment, your attitudes will cost this company a huge amount of money if this case could be referred to CCMA or Labour Court. So please take this matter a bit serious.
Before I leave, I thought we could just... What's all this? Who's this for?
Well, have a seat and I'll tell you.
Oh, thank you.
This is just a small token of the appreciation that I have for your work.
Oh, well, you shouldn't have.
Of course I should have.
Thank you.
Cheers.
Cheers.
We make a tremendous team. I've heard that you've raised some issues with Andre concerning your workload and you're looking for a salary increase. I have a proposal to make.
Oh, well, good. I didn't want to seem pushy, but I really do want that raise.
I want you as my personal assistant. I have an opening at the moment and I want to appoint you as my PA. I need you at my side. Of course, I'll increase your salary with 50%. I'll give you a company car and a cell phone allowance. And, well, it will also mean that you'll have to travel with me quite extensively.
Sure, Mark, I don't know what to say. Why me? There are so many secretaries who are more experienced than I am.
Well, I think you know the answer to that, my dear. You know how I prepare my work and you understand my needs. And you know, Cindy, there's just this something that drives me insane about you.
You're married. And
Jenny doesn't need to know. Come on, Cindy. You'll benefit from it and so will I. You need to wield some real power in the company.
I'm sorry. I have to think about this.
I never knew he would be like that.
Dr. Jekyll turned his Hyde into Mr. Hyde, and now he seems to be quite the opposite.
That's fine. There is this fun. Yeah. Okay.
So,
Mark, I've decided not to take you up on your offer. It would compromise my values and complicate things, so could we just be friends? Please.
if that's what you want, I mean, I can't change your mind for you, but you will regret it, sweetheart.
Well, I may, or I may not. The new meeting notes. Oh, is this yesterday's meeting? That's right.
You better finish off these reports if you want to go home tonight. What the hell is taking you so long anyway? Stop chit-chatting or you'll sit here till breakfast.
What's the matter with him? I can't take it anymore. What's going on? He tried to seduce me. And I refused. And now he won't leave me alone.
Our policy states that we have to create a working environment in which the dignity of every employee is respected, and that must be communicated very clearly to every single employee.
Maybe it hasn't been communicated well to Mark. Does he know and understand that if he continues with this kind of behavior and Cindy resigns and decides to refer the matter to the CCMA, that the company will be faced with a constructive dismissal case?
What is constructive dismissal?
If this is a pure case of sexual harassment, the Labour Court or the CCMA will view Mark's attitude towards Cindy's rejection as extreme, making her working environment very unpleasant.
Yes, according to my knowledge, she wants to resign.
If she does resign and declares a dispute, then Mark's way of dealing with Cindy is a clear case of constructive dismissal.
Allegations of sexual harassment will be dealt with seriously, sensitively, and confidentially. Employees like Cindy will be protected by management against victimization, and we now need to assist her to lodge a grievance so that we can prevent a case of constructive dismissal.
Can't we try to resolve the problem in an informal way?
It's been tried, it didn't work. She now needs to lodge a complaint so that the chairperson can rule that there must be a full investigation, and then there will be disciplinary action.
But how can we deal effectively with this situation?
Well, care should be taken during the investigation that Cindy is not disadvantaged, but also that Mark's position is not prejudiced, should the grievance be found to be unwarranted.
I'll ensure confidentiality in this case.
Thanks, Jane. Continued sexual harassment after warnings or serious incidents are dismissible offences.
It's important that the company's policy must be fair in order to form a just disciplinary code.
But the disciplinary code should also be like a diet, in order to correct, not to punish.
Well, that's the crux of our discussion here today, sexual harassment at the workplace. If you'd like to join us on today's discussion, please call us on 011714 5497 or 5498 or tweet us at Recourse. I just want to once again tell you our guests. We have Patricia Lidwawa in Nelspruit, and we have our friend down in Durban, Ms. Bukani Mngoma in Durban, and in the studio with me here, Mr. Mabaso and Ms. Lisa Vetton. The first thing I want to know is how much of that we saw in that film, short film, is real?
It's fairly typical. What I think might be a little bit unreal is the positive response of management in taking it seriously. Unfortunately, a lot of companies usually try to sweep it under the carpet and hide it. So what that film was good was, I think, starting to demonstrate to management what would be an appropriate response.
Mr. Mabaso?
Yeah, no, certainly. I mean, I think I would want to differ that companies don't take it serious. I think there is a sense of seriousness in dealing with the matter. But of course, because policies always allow that, you first have to deal with issues informally and see how far you could go first. And then you go into the formalities. Because generally formalities always create lots of animosity between the two parties. So people always avoid the formal aspect of it and want to deal with it in an informal fashion. And so, I mean, I'm sure in our discussion we'll see how that happens.
Ms. Patricia down in Nelspruit, are these kind of things coming before the gender commissions from time to time?
Basically, as a point of departure, I would like to indicate that sexual harassment is a gross negligence, and it's a gross negligence in terms of the occurrence of it in a workplace. So also looking into the fact that it's a gender-based abuse, which employers should take into cognizance. And as a Commission for Gender Equality, we protect people's rights based on gender, and then also bearing in mind that is a discrimination based on human dignity and also on equality.
Mr. Mabaso, I don't want to put you on the spot here, but you started a campaign, you set a campaign in motion at the SABC. Are we experiencing some kind of sexual harassment at the SABC?
No, I wouldn't say that. I don't want to say we are experiencing sexual harassment. And the intention when we started the project was to say we should now start creating awareness. Because this is a general abuse of power. You know, generally in the society, there's an abuse of women. I mean, we know that we are a reflection of what happens in our societies. And we said, no, okay, it has been recorded outside that the statistics are high of sexual abuse outside of the environment of the workplace. So we should take an initiative and proactively do so to ensure that we create awareness about what is sexual harassment. It's a very delicate subject, but also it is one that people aren't aware of, as to saying which acts are regarded as those that fall within the scope of sexual harassment. So we're creating that kind of environment now as it stands.
Just there, I just want to know from both of you, and probably Patricia, you can join in if you can hear us. The question is, how does sexual harassment manifest itself?
Well, it can take a range of different forms, and that's why I do welcome Mr. Mabaso not waiting for a problem. In fact, what one suggests to all workplaces that before such a problem rears its very ugly head, create awareness in the workplace that this is not acceptable. And that already helps create the norm in the workplace that behaving in particular ways will not be tolerated. And I think as part of that, you would also run education programs for your employees where you could talk about the kinds of norms that would be acceptable. And so you'd make clear to them that sexual harassment, if we define it very broadly, is unwanted sexual behaviour. And it can take a range of different forms. It could be non-verbal, such as patting you on the bum or grabbing a part of your body. It can be verbal, you know, in the kinds of comments that can be made. It can turn violent. In its most serious form, sexual harassment can obviously become rape. And we also talk about it as creating a hostile environment. So, for example, and one sees this often in workplaces where you have very few women, they might walk into a space which is filled with posters of women with no clothes on. That already can make you feel very uncomfortable because it kind of tells you a little bit about how men in that particular space perceive women. And if you have that kind of environment and you have a whole lot of very unpleasant jokes constantly being made about women, even though they might not be directed at you specifically, they create the kind of hostile environment that the courts recognize also constitutes sexual harassment.
Mr. Bukani Mngoma down in Durban, if you can hear us quickly, what we want to know, what is your experience in pursuance of your profession?
Basically, I think it's important for one to start by actually agreeing with the definition that has been given for sexual harassment. However, what becomes critically important is that we need to understand that sexual harassment, it's broader than just the act of a perpetrator and the person against whom sexual harassment is perpetrated. It also involves the issue of dignity, the issue of privacy, and also what is also important is that one incident of sexual harassment actually does constitute sexual harassment, because there is a perception or a distorted perception that it needs to be persistent for it to constitute sexual harassment. So a single incident itself can actually constitute sexual harassment.
Patricia, from a gender point of view, I think Mr. Mngoma put it there very clearly and said it doesn't have to be consistent. One touch or one joke that is seen to be sexual harassment, that is sexual harassment.
I concur with the previous comments that have been made, because the sexual harassment, it doesn't have to occur consistently. Only one act can amount to sexual harassment. But the most important thing is to register that that is an unwanted behavior that discriminates and infringe on the employee's rights. And then also for an employee to come forward and report such cases. And then also that what prevails is the awareness of such sexual harassment policies. How are they advocated? The awareness thereof. And then also the employer to put platform for people to come forward and have a freedom to say your cases will be handled with confidentiality, and then also it will be treated with fairly.
Mr. Mabaso, exactly what I think Patricia is talking to you as a manager representing the SABC. I see you saying in a pamphlet you put out in that you are holding a series of campaigns to raise awareness. How successful has this been?
Well, we haven't begun with the training and other. We're still putting up posters and we're putting up in the newsletters. I've written a piece in our internal newspaper newsletter.
The
Intercom, yes, to ensure that we just begin the conversation, because I want us to have a narrative from the top to the bottom about this issue. So the workshops are beginning in September, and they will be running throughout the financial year this year.
What form are those workshops going to take?
They're going to take focus groups format. They're going to take. We're going to do training for managers on how to handle sexual harassment, but also we're going to talk to staff to look at what are the signs, but also to assist, because I believe also co-workers must assist those that are not assertive enough to report issues of this nature. Because if I was just talking off air now to say some employees aren't strong enough maybe and fear they are, because remember the sexual harassment also is part of an abuse. The power issues, it's the power relations issues. Managers are more powerful than employees, or also colleagues themselves, because one colleague who's a coach, I coming into a workplace, I'm new, a colleague must train me, must coach me, and therefore they carry more power than me, and therefore they might require certain favors. So we want to bring in all of these subtleties into this very sensitive concept, because I look at it and we say the power relations in the workplace, we must ensure that we don't abuse those. But also similarly, those who want to claim sexual harassment must not abuse their space and say they want to settle scores with managers on the basis of saying that they have been sexually abused. So and as I indicated also in my piece, is that there is a sense that sexual harassment only means it's something that happens to women from men, but the other way around also is true. That young men can also be sexually harassed in the workplace by women who are managers.
We'll continue this discussion here with us, and if you'd like to be part of us and join the discussion, you can call us on 011 714 5497 or 5498, or tweet us at Rights Recourse. We'll be back after the break.
Thanks, Mom. Have fun. You too.
This August, it's open house at Audi. Receive a complimentary extension on your Audi freeway plan to 120,000 kilometers when you purchase a new Audi A4.
Welcome back. Today we're discussing sexual harassment at the workplace. My guests, Lisa Vetten, Mr. Jabulani Mabaso, Mr. Bugani Mugoma down in Durban, and in Nelspruit we have Patricia Lidwaba. What I want to know, Lisa probably can tell us, is this something that there can be some whistleblowing from other members in the who are sharing an office with a lady who's being harassed or whatever?
There can certainly be that they can make an approach to the human resources or management. I mean, I think the other very important link in this chain are, of course, shop stewards. Shop stewards, I think, can sometimes also observe what's going on and can act as intermediaries in terms of what's happening. I think the real difficulty is when you're dealing with very small workplaces of maybe only 3 or 4 people. Then it does become quite difficult because there's nobody to protect you, there's no one to shield you from what's going on. You can't really ask for a transfer out to another division. And often, I think one of the most difficult things about sexual harassment is when an episode happens, people start taking sides. There can be a lot of blame and a lot of victimization as well. So very often, I think if it's going to be well dealt with, you don't have to deal with it between the people concerned, but you also have to look at the larger workplace as well to ensure that there's no secondary victimization, that people don't start saying, yes, but do you see how she dresses? Yes, but she slept with him and now it's just sour grapes because she didn't get the promotion. Mm-hmm. You have to work very hard to ensure that you don't create that kind of a workplace. Because I think what employers sometimes forget is that there is something called vicarious liability. If you are aware of sexual harassment and you fail to take steps, or you perhaps demote the person who is being harassed, you then become liable as well. And we've had a couple of cases in South Africa which have established that employers are responsible for sexual harassment if it takes place. So it's important that the SABC is doing what it is in order to start educating and inculcating those kinds of norms. But as I said, the real difficulty lies in very small workplaces where there's no union, where they fall outside, say, for example, the NEDLAC Code of Good Practice, for instance. That's where you have a lot of difficulty and where it can be a lot harder to come forward.
We'll come back to the NEDLAC Code of Good Practice. Let me just follow from Bugani down in Durban. Bugani, what do you want to weigh in on this issue of whistleblowing if there is something happening in the office and the colleagues have seen there is something wrong going on here?
No, in fact, I wanted to just to build on Mr. Mabaso's take that sexual harassment, it's not only a one-way street, meaning a man being a perpetrator and a woman being a victim. I just wanted to illustrate an example or a possible example where a female employee could be a perpetrator of sexual harassment. A typical case in South Africa, I think we know in South Africa there is a lingo of what we call a band 10. A band 10 is a young person. Let's make an assumption that here's a human resources manager, senior than a band 10. He asks for the band 10 to come into her office and says to band 10, listen, I would like to take you out. And then suddenly the band 10 says, but I think you're old enough to be my mother, and I'm also involved, and also you are my boss, so it's going to be very difficult for me to be able to deal with the situation. Then the manager says, no, age is just a number, we can be able to handle this, can you think about it? Obviously, at that point, even if it does not persist, then you will find a situation where it is a female employee who is using her power of authority in that particular situation in order to influence the decision of a Band 10. So I'm saying we need to balance this, as much as we know that in majority of cases it's women who actually report sexual harassment, but it actually does take place vice versa.
Patricia, one of the questions, I think that's a very good example put there by Bugani Mngoma, but one of the other question is, it's not only, taking that narrative by Bugani, it's not only now a matter of sexual harassment, there's also intimidation, there's also this power relation that is being displayed.
Correct. When we're looking at the sexual harassment, it's a broad word, or it's a broad action. It can be intimidation, it can be a hostile environment, but also the act should also have a result of affecting the victim's performance at work, and then also infringing the victim's rights. But then we also look at the sexual harassment. It can be from a man to a woman, it can be within the same-sex relation. It should be on the basis, it can be on the basis of gender, and then also on the basis of sexual orientation. So it is a broad, vast ambit within therein. And then also looking into the fact that was also elaborated earlier, we're looking at the sexual harassment and also reporting of such cases. People don't report such cases because of secondary victimization. They do not want to be subjected thereto. But one thing that we've realized as the Commission for Gender Equality, through the employment equity hearings that we held throughout the country, is that most of the companies are not aware of the sexual harassment policies. If they're in place, it's either they're in a draft policy or the advocacy is always a problem. And then also the manner of reporting such cases, it's a problem because they are swept under carpet. And then we need to also look at the grievances, how we deal with the grievances, how do we deal with the victims, how do we deal with also the perpetrators therein, and then also to promote other people's rights and not infringing either one of them. And then also advocacy of such policies, that's the utmost important act. Because if such policies are advocated, then people wouldn't be afraid of secondary victimization. And then also we can use platforms like training, meetings, and also awareness from the HR and also from the employer. As a designated employer, they do have the requirement to ensure that the workplace is free from all forms of gender oppression.
Okay, Patricia, we'll continue the discussion. Thank you very much for all of that. You've given us a great deal of thought to go through during this program. If you'd like to join us on today's discussion, please call us on 714-5497 and 5498 or tweet us at Recourse. We'll be back after the break.
Welcome to our Friday edition of A View from the House, coming to you live from Parliament. My name is Asanda Mbeche. President Jacob Zuma officially opens the National House of Traditional Leaders and calls on traditional leaders to work closely with elected public representatives.
South Africa is a much better place to live in than it was before 1994. Many of our traditional leaders can attest to that fact, having seen improvements.
A View from the House, weekdays at 2:30 on SABC News.
welcome back, and we're discussing sexual harassment at the workplace. The question I want to know, I hope all of you can hear me. I want to relate a little bit of a story. What is happening in the Eastern Cape, in the government, there's a huge probe around this issue where employees have come forward and said, we were promoted, we were offered promotion if we do X, Y, and Z. And some of us are now frustrated. Some of us are on the verge of divorcing. The important thing around that probe in the Eastern Cape, which is a very wide probe within the government of the Eastern Cape, is the union now is helping to get all of these people who have been sexually abused or sexually harassed to come forward and tell their story to this committee that is probing the sea. Should something like that happen, for instance?
Yes, and I think under those circumstances, some of what has taken place could conceivably fall within the definition of rape. And if you read the Sexual Offences Act, the new Act of 2007, it talks about coercive circumstances in recognition of the fact that much consent is not free or voluntary, it's submission. And it occurs under circumstances where somebody is able to coerce you in one way or another. And one of the circumstances recognised as coercive is when somebody is in a position of authority, be that in a school or in a workplace. So it crosses over from labour law into criminal law when you extort sex from somebody, promising them jobs or something else in exchange. That the law recognises under those circumstances, it might look like you're consenting, but you're not actually. So I think it's important that people be aware that some forms of sexual harassment are actually criminal and are dealt with in terms of the Sexual Offences Act. And I think it's important to treat them as coerced rather than voluntary, because there's often this accusation, particularly made towards women, about, oh, you slept your way to the top, which is neither right nor fair, because in the first place, no employer should be offering sex or offering benefits in exchange for sex. And I think anybody who does do that, it should be disciplined. One shouldn't look at the victim and say, oh, well, you slept with him, so now you're just as bad as him.
Mr. Mabaso, earlier we spoke about whistleblowing. Should unions be working with management in trying to stem the tide of these kind of things?
I think I personally welcome the move by the Eastern Cape government, and that one thing that encourages me is that the unions are working close with management, and that's the kind of social partnership we want in the workplace, so that we deal with the scourge once and for all. And I think, of course, the delicacy of that one is whether it may end up being a witch hunt of some sort at the end of it all. But it is critical, though, that the people who reported must be protected, and they must be seen to be protected. Because if only is about heroism from the government or from the Eastern Cape government, they need to show that they can defend the people that reported. Because when they are left alone and left vulnerable, then it becomes problematic.
Bugani, one of the things, if you want to weigh in on what we have discussed now, and probably also touch on this thing of whether this thing at what stage can it turn into a witch hunt?
Yeah, I think what is important, what is happening in the Eastern Cape, I suspect there is also an element of quid pro quo type of sexual harassment, where people are actually offered job opportunities or promotional opportunities in exchange for them having sexual relationship with a person that is a boss. Now the challenge though is that if that has happened, and one wonders as to why did the system not pick it up if it happens at such a massive scale. So there is a failure in the system in terms of existing processes and procedures that need to be able to detect that. And one of the starting point will obviously be having a policy which outlines the need for employees and also managers to be able to be very vigilant and be able to deal with issues as they come. Now, because that has already happened, obviously we need to be able to be asking ourselves as to what actually happened. But the employer in this case, if there is an attempt by the employer to actually try and correct what has been, a mishap, I don't think that the employer will then be accused of vicarious liability, because the employer can argue on the basis that in fact I was not aware at the time that happened. But immediately I became aware of it happening, then I actually instituted the processes to try and eliminate such. But it has happened on such a massive scale that you can then realize that maybe lack of the sexual harassment policies maybe could also have led to a situation in which the Eastern Cape found itself in.
Mr. Bugadi spoke about the quid pro quo sexual harassment type. What is that? Can you explain that in further?
It's exchanging, it's the exchange of sexual favors where you offer something in exchange for sex. So I offer you a job. So you sometimes see it very often. Security guards, for example, who may often deal with job applicants, will say to women, I'll put your name on the list, I'll let you jump in the queue, but you need to sleep with me first. That's at a lower level. But it could be your immediate boss who says, if we go out together this evening and have a nice time, I'll be sure to try and put in a good word for you and really help you get your promotion. So it's really somebody taking a benefit and offering it in exchange for sex. And of course in a workplace that can never be permitted, nor can it be permitted in an educational institution either, because we sometimes see teachers or lecturers offering better marks or other perks in exchange for sex. So I think it is important that we also realize that quid pro quo doesn't only happen in the workplace, but can also happen in educational institutions and wherever somebody has a benefit that they can withhold or give that somebody else would like.
Mr. Mabaso, the other thing for me is, does the fact that people are given preferential treatment as ladies in an office by a manager also become sexual harassment?
No, not necessarily. I mean, as long as that it's not intended to solicit certain benefits thereafter, it cannot be seen as sexual harassment. But remember, there's also Employment Equity Act that we need to deal with, which then talks about issues of unfair discrimination. And so we're trying to equalize the workplace and ensure that we redress some of the historical past around the issues of gender. So for as long as it doesn't then end up with people requesting certain favors, then it cannot constitute sexual harassment. But the important part for me, I think, is something that we haven't raised. We spoke about it off air. The issue of culture and norms and what
yes.
that we spoke about, to say in society we men have learned to say they should praise women. And it's a very tricky situation, and they praise, and we know that, I mean, different cultures can always do it in different ways, whether do lupavu and things of that nature can, don't be up, something to that effect. But a guy says, I'm just praising, I'm appreciating how beautiful you are. Those are kind of things that people also bring into the workplace and say, you look nice and beautiful. And so these are kind of subtleties. We get them from, and as I say, we're not divorced really from our society, and these things come to the workplace, and these are intricate parts that we deal with on a day-to-day basis. And we will bring them into these workshops and deal with these things and say what are the things that are not allowed now in the workplace.
Patricia, as a Chapter 9 institution, I think I'm not wrong there that Gender Commission should be a Chapter 9 institution. What role do you play in getting companies or even government departments understand how they should deal with these issues, especially sexual harassment at the workplace?
Thank you for granting me the opportunity. You are correct. We are a Chapter 9 institution, and we are independent, and we we execute our duties without fear, favor, or prejudice. And how is the Commission for Gender Equality we're dealing with the sexual harassment in a workplace is that mainly our mandate is to monitor, protect, and promote, and to ensure the eradication of gender oppression in a workplace. So what we do is we have conducted what we call employment equity hearings throughout the country, wherein we subpoena all the government departments and then also subpoena private institutions. We monitor the implementation of gender mainstreaming, wherein we're looking at also the gender-sensitive policies. Are they in place? For instance, the unfair discrimination policy, and also looking into the sexual harassment policy. Are those policies in place? Are they in a draft form? When were they implemented? When were they adopted? We look at all those things. And then also we look into how the grievances are lodged, and then also looking into the processes. Are the processes fair? Are they discriminatory? And then also we put them to the proof thereof to say they should produce them, and then we give them a direction going forward to say what they should do in terms of the compliance, ensuring that, making sure that we execute our duties in terms of the CGE Act that grants us powers to monitor those institutions.
Well, we are discussing sexual harassment in the workplace. You can join us and talk to us on 011714 5497 or 5498, or tweet us at Recourse. We'll be back after the break.
Have we seen the last of you in politics?
I don't know. No, I'm just okay now with the work that I'm doing. Let me just do one thing at a time. So I don't have any plans for politics.
Watch Question Time with me, Mpho Tsedu, Monday to Thursday at 5:30 p.m. on the SABC News Channel.
Welcome back, and let's have a look at what people have been saying on Twitter around this subject. And the tweets coming up there. Chinemo Elias says, please can your guest explain more about what is sexual harassment and what are the signs that someone is sexually abused. Kerry says a person may also obtain a protection order into the protection against harassment. We'll talk about that when they come back to us, and as we continue our show. Well, Lisa is familiar with this case. Wits University went through a rather traumatic process in this regard. Did the institution go about this the right way? But before we give a response, let us first listen to Vice-Chancellor Professor Adam Habib.
Professor Adam Habib is the Vice-Chancellor of the University of the Witwatersrand. You have seen him all over the news lately. Wits, of course, being all over the news for not tolerating sexual harassment. He's in studio with me. Talk to us about your moves at Wits and what's happening with the lecturers.
Well, there's no doubt that the young women particularly have been harassed at Wits, and it's been going on for a while. There's been some rumors. We've tried to investigate it. We've never taken it very far. And then what happened early on in the year is the newspapers blew it. And that forced the institution to start investigating it much more robustly. We found out that there was substantial evidence that people had sexually harassed young students. And so it's important that we act. So what we've done is we've had 3 hearings. There are 4 people charged. There are 3 hearings. The disciplinary hearings of all 3 pronounced that the individuals were guilty and recommended dismissal. And within 8 hours, we dismissed all 3 individuals. We're acting very rigorously, very quickly, very robustly to send a very strong signal that sexual harassment will not be tolerated. This is a free space. You can't provide higher education if this is not a free space for young women and men. And so we're going to send a very powerful signal around this.
Well, probably we should try and answer those questions on the tweets. One of them was, one can get a protection order in terms of the Protection Against Harassment Act. How do you get this protection order?
I think it's important to also just be clear that the Protection from Harassment Act is also dealing with stalking. And it's not just intended to protect in the workplace. It's a very wide piece of legislation. And I think it fills an important gap in that most of our legislation has only protected those who are in workplaces and in institutions. So it's done nothing about those people who are harassed in the streets by their neighbours or who are being stalked by unknown people. So it's important to understand that it has a broad ambit. You can use it in terms of, it works very much like the Domestic Violence Act, in which you go to court and you obtain a protection order, which is then served on the harasser, instructing them not to harass you in any way. And if you don't know who it is, then the protection order can come with instruction to the police that they need to go and investigate and find out who it is. And I think what's very important is it introduces a whole range of new remedies for dealing with electronic harassment. So it is an option, but I would also suggest that people don't use that alone in the workplace, because management actually has to do something about the problem. They can't just rely on you having a protection order against the person you're working with. They actually have to take steps to ensure that it stops happening. But it's useful for cases for those harassers who are stalkers.
Excuse me, I know you had reported to us that you've got a bit of
Yes.
flu. Let me get Bukani to answer some of those questions. Except, Bukani, probably you want to weigh in on the electronic harassment that Lisa alluded to.
Yeah, I think that will that is part of different categories of form of harassment. Obviously, we've got visual harassment, non-verbal harassment, electronic harassment. So it's a different category. But what is important, I think the critical issue here is that there needs to be a policy that guides all employers. In fact, the NEDLEC issued the Code of Good Practice on eliminating sexual harassment in the workplace. I think employers need to be able to look at that. In fact, in South Africa, we've got adequate legislation to actually deal with the issue of sexual harassment, flowing down from the Constitution to Employment Equity Act, the Labour Relations Act. There is quite enough for us to be able to deal with this issue. The reason why we still experience it is more the issue of willingness on the part of employers to actually take this issue seriously. And my view is that I even said, if I was a member of legislature, maybe I will change the phrase from sexual harassment to sexual bullying, because I think bullying denotes a very strong message. It's got a very strong connotation that something should not be tolerated. I think other people think that, excuse the pun, harassment is just sexy. But if you were to say it is sexual bullying, I think people will actually start taking it seriously, because no one actually wants to be bullied.
Mr. Mabaso, I will get into trouble if I don't ask this question. Can men be sexually harassed in the workplace by other men?
Oh yeah, most definitely. As we've heard before, that the harassment happens across genders. It also happens between the same people of similar sex. It can happen. As long as there's a sense that a person is requiring certain favors, or is also engaging in an unwarranted, unwanted, physical and non-physical move towards another person, regardless of their gender, that must be reported. And that is, for me, sexual harassment. I think also what is important is that there's been always an issue of whether people are empowered or disempowered to deal with the issue of sexual harassment. I think Mr. Ngoma was trying to deal also with that aspect. Because I feel that before, people were after the case has been dealt with internally, people had to go to the labor court, and they were not empowered to go to the CCMA. CCMA was not dealing with these cases. And as a result of that, people will say, I don't have money to be dealing with lawyers. I don't have money to. So they were disempowered. I'm grateful that with the Employment Equity Act now, they've been given an opportunity to say the CCMA can now deal with these issues. So people would be able to open up and report as much as possible. And I'm sure we're going to see many cases that are going to be reported now.
Lisa, you wanted to weigh in on something?
Yes, I think it's also important to understand that in addition to sexual harassment, we also have gender harassment. Mm-hmm. And what that refers to is where somebody is abusive, treats you badly, harasses you on the basis of your gender. And that often happens in same-sex settings, where you might have men harassing other men because they're not seen as manly enough, where they'll say to him, are you just a sissy, are you this, are you wearing that? So you can find often a lot of that comes, I think, starts to translate into homophobia, where somebody starts being harassed because they're not behaving like a proper man or a proper woman. So you might have an employer who says to a woman, stop wearing those pants all the time. You need to start wearing a dress. Why aren't you wearing makeup? Why do you look so unattractive? You need to make yourself better looking for the customers. That too is a kind That too is a form of discrimination, I think, where you're taking the gender stereotypes and bullying somebody on the basis that they are not conforming to those stereotypes. So I think it's important that we also include that in our understanding, because you did have a tweet, I suppose I should call them, who was asking what are the different forms that it can take. So I mean that kind of intimidation, harassment of you because you don't want to fit a gender stereotype also needs to be understood as harassment.
Well, when we come back,
rape as well.
You still have some more to say.
I'm just going to say, and then I think people shouldn't forget that, as I mentioned earlier,
yes.
rape can also be a form of the most serious form of harassment.
Well, as we said, we're discussing this topic, a very exciting topic here. It's actually not very exciting, but it's a topic that's very important that you should talk about in the open. As Mr. Mabaso has pointed out, we are going to have those kind of discussions here at the SABC, whether they're going to turn down, they're going to formulate, that's going to be a way of formulating a policy. We'll see when we get there. But join us on Twitter and tweet us here on Recourse. We'll be back after the break.
Cultural Village is a large family homestead with 16 huts, each of them with its own specific purpose.
My responsibility, it is taking care of the family. As far as cleanliness is concerned, I have to make sure that I keep the home as clean as possible every morning when I wake up.
That's Kaleidoscope, Sundays 5:30 p.m. on SABC News.
Welcome back. We continue our discussion on the sexual harassment at the workplace. Let me go to Nelspruit in Mpumalanga. Patricia, the question I want to ask you at this stage is, if something of this nature is reported to the Gender Commission and a company or an institution does nothing about it, can the Gender Commission then say, we will issue this and that sort of like statement and then go into that company to investigate that?
Correct. As the Commission for Gender Equality, if we receive such a complaint based on sexual harassment, then we take it upon ourselves to investigate such matters. We have powers to go into the certain company and then also find out what really transpired as an independent body, and then also looking into their policies, what are the pros and cons, and then also have a recommendations to that, what is it that the company should do going forward. And also maybe compelling them to have a sexual harassment policy if they are not in possession of it.
The code of good practice, Lisa, that you spoke about earlier, how readily available is this? Can I get a copy and go through the copy and study it?
Absolutely. You can just go onto NEDLAC's website. You can even Google it and you'd be able to find it. In terms of the code, every company should then go on to develop their own policy. But that code is there to protect those who are in a very small workplace where there isn't a policy or where companies haven't gone ahead to develop the policy. So people can look at that. We've spoken also about the other legislation, like the Employment Equity Act. And again, I want to emphasize people shouldn't forget the Sexual Offences Act, because that can also deal with certain forms of sexual harassment. And there is, of course, the Protection from Harassment Act. So we have a legislative and policy framework. I think the difficulty is that perhaps we don't always appreciate just how difficult it is to bring such a complaint forward and how much support is required in order to be able to pursue a complaint. Because I think one of the things that's been rather disappointing is there have actually been very few cases that have gone to the Labour Court or to the CCMA on the basis of sexual harassment. What usually happens is that most victims ask for a transfer or they go and look for another job because they are frightened of taking it forward. And sometimes they've seen what happens in the workplace if you do take complaints forward. And as Professor Adam Habib was saying earlier, sometimes companies know about this and it takes a crisis before they actually do something. I think for those who've gone and laid complaints and seen them go nowhere, it actually silences everybody else because they can see there's no point. And that's when you end up with a crisis situation.
Just want to get a final word from Bongani Mngoma down in Durban. Bongani, a final word from you?
I think what is important for me is that the recent amendment to the Employment Equity Act will actually make it easier for employees to be able to take matters outside companies, because CCMA now has jurisdiction in terms of arbitrating on matters of sexual harassment. I think that is a big plus for employees, because it was cost prohibitive for any employee to be able to try and actually take a matter to labor court. As a result, they will just abandon, or in fact, they will not even report it because it is also seen as a career limiting move. For me, that is very critical, and I think the recent amendments will obviously go to a long way. It might be that there will be more cases, not necessarily because there is an increase in sexual harassment, but it's because people can be able to afford, because CCMA is the cheapest form of referral in terms of the legal system that we have in this country.
Patricia down in Nelspruit, final word from you, from the position of the Gender Commission.
Well, as for the position from the Commission for Gender Equality, I'd like to concentrate more on the legal remedies or the recourses. Firstly, you know that there is an internal investigation that must be launched by the employer or designated employer. And then also the employees or the victims should know that when the matter is not resolved within 60 days, they can refer that to the CCMA, having the jurisdiction to adjudicate such matters. And in the interim, if the sexual harassment continues, there are other remedies that can be invoked, wherein there is also a protection order that can be attained to ensure that the interim remedy is attained, to ensure that basically to eradicate the continuous behavior of sexual harassment. And also looking into the fact that we have a PEPUDA Act that also that also eradicates the sexual harassment policies, wherein there is implementation there too. And then also we have your labor court remedies, wherein one can follow if the dispute is not resolved at the CCMA.
Patricia, thank you very much. We're quickly running. Patricia, thank you very much. We will give the Gender Commission's number so that people can phone or go to the Gender Commission on those issues. We're quickly running out of time. Final word, Mr. Mabaso.
I think as a SABC, from the top, the board has supported me in this regard. The EXCO has supported me in driving this process forward. But also, I think to encourage also my colleagues in the HR fraternity to ensure that we do not victimize people who have reported sexual harassment in another company and then say we're not going to employ them.
Lisa?
I think it's important that people know that there are remedies, that they can use them, and if they're stuck, to approach an organisation, for example, some of the organisations like People Opposing Women Abuse or the CGE, and I think also a challenge to unions to take this up and educate their members and their shop stewards so that we can also have it happening not just in the corporate sector, but also within unions. There is the kind of education and support to take it forward.
Well, this has been Rights and Recourse. This programme is repeated at 10 tonight and at 5 on Monday morning. Thank you to our guests, and from all of us in the studio, good afternoon.